2E.
Obtained the interim order because there is a matrimonial case pending between the petitioner and lawyer. In that matrimonial case, 10,000 interim is awarded. He challenged before this honorable court, and this honorable court stayed the matter by directing to pay 6,000 per month. So matter may be
Not paying.
is not regularly paying. Lord.
How regularly is not paying?
So arrears is there, balance of arrears.
How much amount?
Have to inquire.
Which year is that? Which year?
2022, Miller, B group.
We'll see. Yes.
Permitted. This is the second time I'm listing, filing a memo for listing. So now here a 2023 matter. The file is CMS for maintenance. Challenge the same. There's an ex parte order placed, formed against me. I'm challenging the same. There's a delay more than 365 days.
Stay is not there.
Stay is not there, my lord. It was moved
from 2023.
No, my lords. The matter is this is a fresh matter. 2025. We filed it before the vacation bench, but because we
it could have come if it is office objections are there.
Office objections were complied, my lord.
No,
office objections were complied.
If the office objections are complied, it has to. If it is, it will come tomorrow.
Much okay.
Page wise. No, I let's call all the matters. All the.
Serial number 26, Your Lordship.
Here for petition in this case.
For the respondent in this matter. Matter may be posted on Monday. Senior.
Have an interim order?
Well, no. See, 7th matter is family court matter is listed on 7th matter. Before 7th, any date, my lord.
No, I'm saying you have an interim order in your favor.
No, ma'am.
List the matter on 4th
Problem.
at the request of land counsel for the respondent. Yes.
Shall
Lord, I appeal for the, Lord, this husband petition. Lord, kindly see the impugned order passed by the Lord, the trial court, granting it 10,000. But reason, kindly see the reason, Lord, 15:9, page number 15:9, Annex G.
No, what is this caption for this? What is this disposal?
No, your lordship, not earlier, you wanted, Lord, your lordship wanted to dispose of the matter. That's why the heading was given
For
to,
that disposal.
that's why it's coming from, Lord. Lord,
Appear to be so.
earlier it is long back, Lord, your lordship has passed the order of this. Lord, kindly, if subsequently one more application which has been filed. Lord, the all suppressed, Lord, the facts which has been, Lord, narrated by the, Lord, wife, that she is not working. Lord, kindly see the application, Lord, Annex H, along with
Where is
the,
the counsel for the respondent?
he is also filed, my Lord, the enhancement of a petition that has been also tagged in the along with this. Kindly see, my Lord, for a moment, for a one
No, what
moment.
is the purpose of seeing it when the counsel for the respondent is not here?
No, the stay is not there, then, Lord, in this case.
24
Because your,
matter
no,
not
your
occurred.
lordship, because this is the reason, Lord, where your lordship wanted to dispose of the matter. So because of that, the no interim order has been
You
granted.
are for the petition in which petition?
Lord, the first petition, 3460.
The counsel for the petition in WP 3460 is present. No representation on behalf of the petition in WP number 10584 of 2024, list 10584 of 2024 for dismissal day after tomorrow along with this matter. Yeah, delete from the caption disposal. Yes, next.
Appearing for the petitioner in serial number 2, Your Lordship.
It's a letter. An order was passed directing to dispose of the matter within a period of
1 year, Your Lordship.
1 year by order dated 29th August 2023. Now a letter is addressed for the 5th Additional Principal Judge Family Court that the case is posted for the reply arguments on 25/6/2025 in view of the several other direction matters that are pending before the court. Another 2 months' time is sought for disposing of the matter. Concerning the letter dated 25/6/2025, the another two months' time is granted, and it is made clear that no further time will be granted. Yes.
Number 3.
Because this is the jurisdiction aspect. The child
There is
was,
non-compliance of office objections.
that has been complied.
Why they have written again? Take that IA number 2 for interim custody. direction memo for correction in the typographical error.
I think
Order
there was
dated
some,
15/4/2025, filed by the respondent. What are the objections? It says non-compliance of office objections raised at scrutiny stage.
Millards,
It is
last
still
time I
there, I think.
remember we submitted that, I'll do one thing, Millards, I'll have a look at it today. If there is any still persisting and complied, can be taken up. May I request to be taken up tomorrow if it's possible?
Office objections shall be complied with.
I'm sure it's
If the
complied.
office objections are complied with, list the matter tomorrow.
Great. There is an interim order stay that.
Interim order earlier granted is extended till tomorrow.
Petitioner, please.
Again, for amendment also objections. Office objections raised on amended petition, that is page number 5 and 9. Corrections not carried out.
Lordship, may kindly
Office objection shall be carried out. If the immediately after the office objections are carried out, list the matter.
Lordship, appearing for the petition, the office objection raises, Your Lordships, that have not furnished a written statement of the main petition. Your Lordships, what is under challenge in this writ petition is an IA, Your Lordships.
Let's see, what is that? What did they say?
IA has been filed and objections to that IA has
Cover
already been
admission
furnished.
papers were not for registration following of the written statement to be filed.
I filed the IA that is under challenge, Your Lordships. Also, the objections to that IA has already been furnished with this.
What is the difficulty in filing this?
It's not available, Your Lordships.
How can it be?
Urgency
When the case is
is,
pending.
no, urgency, Your Lordship, is that the matter is listed for final arguments today, Your Lordships.
So even when the case is pending, you don't have the written statement.
Sought from the trial court advocates, Your Lordships, and they are finding a little difficult to furnish the same. The contention raised by the respondent can be well aware in the objections that has been filed, Your Lordships. The applications filed before the trial court, Your Lordships, is that the have summoned certain documents which have been denied by the respondent. Your Lordships,
MC of 2024 is posted for final arguments.
yes, Your Lordships.
Which court is this?
Principal
Bangalore.
Mangalore, Your Lordships. The impugned order.
For the husband.
I'm for the husband, Your Lordship. Impugned order can find place at page number 19, Your Lordships. 21 orders, 21 to 23 is the impugned order, Your Lordships. I filed application to reopen the evidence of myself, Your Lordships, PW1.
When the evidence is closed?
The evidence was closed on the 1st of June, Your Lordships. And that to the evidence of respondent, Your Lordships. During the cross-examination of respondent, there were certain documents that had been sought by me and which was duly admitted by the respondent that she will furnish. And there were certain aspects, Your Lordships, that she had denied.
What is the document? What is the document to sought?
The document that have been sought, Your Lordship, is that.
Come to your IA.
IA finds place at page number 34, Your Lordships, onwards. "39, Your Lordships. Much apologies, 39.
Where is the affidavit? A memorandum of facts.
Page number 39, Your Lordships.
Above matter is, read that. Page number 40.
3940. That the above matter is now posted for arguments. Submitted that after conclusion of cross-examination of RW1, said witness deposed falsely before this honorable court and made several baseless allegations against the petitioner which are devoid of truth.
Can
Not-
anybody file this kind of an application? Vague. She deposed something. some false statements. So I want the documents.
No.
What is that she said? What is that you want to produce? Nothing.
Now, the main contention, Your Lordship, is that
Contention we will understand from this affidavit.
affidavit.
You don't say anything. Why should the court allow that application?
Now, the
What is the purpose of filing an affidavit?
supporting document is important, Your Lordship.
No, not supporting document. What is that you, please read that memorandum of facts.
Made several basis allegations against the petitioner which are
Witness
devoid of.
deposed falsely before the court. What is that she deposed? How is that you are affected by it? Nothing. In order to establish his innocence and clarify the record, to summon the person. Who is he? What did she say? Nothing.
Your Lordship, the respondent is an employee in a cooperative society, Your Lordships. There she has swindled certain funds, and there even my account, that her husband's account, was also involved. Thereafter,
What is the, you have filed the MC seeking divorce on what ground?
mental cruelty. This was one of the mental cruelty that has been.
Let's see your petition. Let's see your petition.
Yes, Your Lordships. I filed petition at page number 27 onwards. The contention that I'm raising is at paragraph 5, Your Lordships. Paragraph 6 onwards, petitioner submits that respondent had a very bad habit of telling lies for each and every matter, which was not liked by the petitioner. However, petitioner did not bother too much, thinking that the respondent will mend her way at future. Petitioner submits that respondent started
Come to the impugned order. Come to the impugned order.
21 onwards. Sir.
Yes, please read.
Petitioner husband has filed IA number 15 to 17 under section 151 to reopen the case for further evidence. Under order 16 rule 1 read with 151 to issue summons to Inspector of Police, Cyber Economic and Narcotic Police Station Urva, Mangaluru to produce document and to give evidence, and under order 18 rule 17 of the CPC to recall PW1 for further examination. Respondent wife has filed separate objections to IA number 16 to 17, heard both the sides and 17, both the sides, peruse the contents of the applications, accompanying memorandum of facts and objection filed by the respondent. Petitioner husband has filed petition under section 10 clause X of the Divorce Act seeking dissolution of marriage and custody of the minor child. Respondent wife has filed objection and counterclaim seeking dissolution of marriage with petition under the ground of cruelty. Both parties have already adduced evidence and cases pending for final arguments on merits in the
Yes, I
memorandum.
do not find any reasons to interfere with this order.
Your Lordships, on finally, I would like to take the attention of this court to one of the documents that has been furnished in support of this application. It can find place at page number 36, Your Lordships. Now, the main reason why I'm seeking it. Now, if at all it was in my position, I would have.
What is the impact or what is the connection of this and how is it useful for the court?
Because Your
To grant
Lordships,
divorce on the ground of
page number
cruelty.
36, Your Lordship, that's very important. Can you kindly be perused? Translation copy has been filed at 37. It's in Kannada. The translated copy is filed at page number 37. This is the RTI endorsement issued by the police, Your Lordships, wherein an affidavit was filed by the wife admitting for the swindling that has been done. The harassment that has been caused to the petitioner husband was through the funds that have been, because even I went through, I was also arraigned as one of the accused in the FIR, Your Lordships. And even my parents, my mother was also arraigned as an accused in this FIR. Now, she has filed an affidavit before the police station admitting for her fault and requesting the court to issue a B report stating that whatever funds have been swindled will be refunded. And she has accordingly filed an affidavit and also refunded the entire amount that has been swindled, nearly 20 lakhs. The affidavit will disclose all these averments, Your Lordships, admitting with the signatures of the respondent. The respondent is clearly denying this document. Page number 37 discloses the fact that, Your Lordships, it was specifically denied by the respondent to the police to not furnish the document sought by us through RTI. Now, the only person who can produce the document is, Your Lordships, the Inspector of Police, and that is why he is being sought to substantiate my claim of mental cruelty. This is one of the major contention, Your Lordships, to allow the application.
Please come. Agreed with orders passed in. I number I number 15 to 17. dated 10/6/2025. The petitioner husband is before this court. Parties are referred to as wife and husband for the sake of convenience. The husband had filed MC number 179 of 2024, seeking divorce on the ground of mental cruelty. After the evidence of the parties is closed, at that time, the present application came to be filed to summon the inspector of police to produce the entire file of crime number 21 of 2023, including the affidavit filed by the wife. In support of the said application, the memorandum of facts was stated, wherein it is stated that the matter is now posted for arguments. It is submitted that after the conclusion of the cross-examination of RW1, witness deposed falsely before the court and made several baseless allegations against the husband, which are devoid of truth. In order to establish his innocence and clarify the record, it is essential for the applicant or petitioner husband to summon the inspector. Furthermore, the documents sought to be summoned is highly relevant and material to the adjudication of the case. And it is also undertook that the proposed witness will be examined without seeking any unwarranted adjournments. Hence, he sought for summoning the inspector along with the case record. That application came to be dismissed by a impugned order, wherein the court has observed that the both parties have already adduced evidence and case is pending for final arguments on merits. And the court has also discussed what has been stated in the memorandum of facts and the contentions of both the parties. And the court observed that the husband and wife are shown as accused number 2 and 3 in Exhibit P3 FIR registered by the crime branch in crime number 21 of 2023. And Exhibit P4 is a copy of the first information statement lodged by the Secretary of the Society. Exhibit P5 is a final report produced by the police in the said proceedings. The husband has already produced the documents, and the court felt that summoning the inspector of police and the entire file relating to crime number 21 of 2023 and affidavit are not relevant for the decision in the present case. And summoning of those documents on the witness is irrelevant for deciding the dispute in this matrimonial proceedings. And accordingly dismiss the application. Next paragraph. Learned counsel appearing for the petitioner submits that the wife had put the petitioner and the entire family as the lot of mental cruelty, subjected them to mental cruelty, and because of her acts, the entire family was shown as accused. To demonstrate the same, which is denied by the wife, it is relevant that the officer be summoned along with the documents. The court, without considering any of the contentions raised by the petitioner husband, had dismissed the application. Anything else, Mr. Counsel?
Page number 36 and 37 endorsement, Your Lordship.
He submits that the endorsement by the police, which is filed at page number 36 of this petition is very much relevant, and the same is denied by the wife. As such, summoning of the officer, as such, they had to file this application to summon the officer. He submits that if this application is allowed, they would examine the officer without any further delay.
One more submission, Your Lordships. Efforts have been put by myself by filing RTI application and thereafter denied by the,
It is submitted that when he has made an application in the RTI Act, the same was not given to the petitioner. As such, all the more it is relevant and appropriate to allow this application. It is submitted that if this application is allowed, no prejudice would be caused to the respondent wife. Next part. Having heard the learned counsel for the petitioner, peruse the entire material on record. The MC is filed seeking divorce on the ground of cruelty. On the ground of cruelty. The wife, the evidence is closed. Now at that juncture, this IA came to be filed to summon the inspector of police and also to summon the record pertaining to the crime. This court has perused the memorandum of facts in support of the IA. Absolutely no whisper with regard to what is that the wife had falsely stated, or what is that the allegations that are made by the wife, and for what purpose the petitioner wants to, for what purpose the petitioner wants to summon the inspector and the record. The whole purpose of filing an affidavit in support of an IA is to state precisely what are the reasons for which they have filed this application and what is the requirement of that, which is absent in the application that is filed before the court. Then when the MC is filed seeking divorce on the ground of cruelty, and he has alleged several acts with regard to how the acts of the wife amounts to cruelty. And as rightly observed by the court, Exhibit P3 and the Exhibit P4, Exhibit P5, the final report, are before this court. And the finding of the court that these documents are irrelevant for considering the dispute between the parties, in the considered opinion of the court, is a well-considered order and no interference is called for. Accordingly,
Your Lordships,
petition
one
is
final
dismissed.
submission, Your Lordships. If at all this honorable court, since this honorable court came to the conclusion that the affidavit is not, the IA is not supported by the affidavit,
Not only that, I have stated further also.
Your Lordships, we may be permitted to file a fresh application with the IA, Your Lordships, because
Not
the
at-
affidavit sought is very relevant and has been specifically denied by the wife, which goes to show that there is adverse inference drawn, which can be substantiated once summoned, Your Lordships.
What is this, 5?
Filing the affidavit, as per my lord's order, my lord.
Next 6-1. What is called as 6? Yes,
Filing the affidavit, my lord said, asked us.
served her.
I've served a copy.
Yes, they served me a copy.
She has also filed, my lord, an affidavit today.
I'm filing my affidavit to my lordship.
But
I think we'll take up this end of the list.
I may have to have a look at it, my lord, what she has filed, because my lord's order,
He's also filing today.
she is also filing today. Only
Filed
difficult.
today?
I'm filing today, my lord.
Yeah, you gave him a copy?
Yes,
I have
yes, she has
the copy.
furnished me a copy. My only concern is, my lord, just see her affidavit, but I feel it is not in consonance with what my lord said directed. Because my lord said, my lord, property is movable, immovable. My lord, she has filed an affidavit, my lord, with regard to the various cases, etc., subject to what my lord should.
I have mentioned everything with regarding to my mobile and immobile. Yes, my lordship.
Give the order.
My lords, order dated not
11/6/2025.
The order is to the effect both husband and wife shall file an affidavit before this court with regard to their movable and immovable properties.
I have just mentioned it
Husband
in a
particularly
paragraph
shall
form, my
place before the
lordship. I have
court-
not put it in a box form like the Rajesh versus Neha thing, because my affidavit of assets and liabilities already filed as per this. Since my lordship said file an affidavit, I have filed it in a paragraph form. That's the only difference. Matter is the same. If my lordship wants, I can file it in the box form as per Rajesh versus Neha's
Anyway,
format.
if it is disclosing all that, why you want it that way? If she's stating that in the form of an affidavit, it's fine.
I'll have a look at it, not because
My
When you
lordship,
want.
I also need
Please,
time
ma'am.
because they have submitted a whole lot of
Both the parties
documents.
has with order dated so and so has filed their respective statement of assets and liabilities. Does this matter when?
Madam, 25th, if it's okay, I have a matter in Bangalore on the 24th. I'll be coming for that.
25th?
25th of this month,
Yes. 25th.
much obliged.
24th, right?
We have 24th, the contempt case.
I have it on 24th itself.
25th, my lordship. Can't run between two. I don't have anybody.
He's also busy. 25th. So that you can, both of you can file it in the registry.
In the box format,
No, not box format.
in the office, in the filing counter.
Yes, yes.
Perfectly fine.
Please.
My lordship may it be recorded as,
Also.
may it be
Both the parties submit that they're going to file their respective statement of assets and liabilities today. And it is served on the other side.
may it be recorded as part heard, my lordship. Just because my matter has already been heard, half of it. If it again goes to a new bench, we'll be starting afresh with the whole thing, my
So
lordship.
now, even if it is her, it is as parted also, no useful purpose will be served.
But I'll be highly obliged if it would be recorded as part heard.
I have no difficulty, but I know the court's difficulty. But may not be.
Please, my lordship, I insist.
Yes, yes, next.
Please.
Much obliged.
My opinion for the petition, my lords.
Yes.
I have submitted the certified copies, my lords. The memo dated 28.
So IA need not be,
Please, my lords.
IA 1025 is filed, seeking dispensation of the original of the certified copies of Annexure A. It is submitted that already the copies were filed. Hence, no orders are required on IA number 1 of 25, accordingly closed. Yes, what is it?
Please, my lords. Maintenance proceedings, my lords. There's an impute order passed by the below courts, my lords, awarding the maintenance of rupees 7,000. Please, my lord. Previous to that, 8,000, my lord. Previous to that, so my lord, there was a DV proceedings which was initiated by the wife. There also they have awarded of the rupees of 7,000, my lords.
So now 7 plus 8,
Yes, please, my lords. Total it's 15,000, my lords. I'm a vegetable.
salary,
Please, my lords.
your salary.
My lords, I'm a vegetable vendor. I don't have any fixed salary, my lords. I have filed my assets and liability code below, my lords, without taking.
Come to the imprint order.
Please, my lords. Annexure A, my lords. Page number 10. Please, my lords. In page 18, my lords, whereas stated, my lords, para 12, my lords.
Para?
12, my lords. Page 18. Running page, my lords. Previous to that, my lords, the marriage took place in the year 2021. Thereafter, there was dispute between the parties, and they have entered into the agreement saying that they won't initiate any complaint. Subsequent to that, my lord, she has initiated proceedings under DV Act, my lords. Order is at page number 25, my lords.
Please come. The petition is before this court agreed with the orders passed in I number
I number 2, my lords.
I number 2 in criminal miscellaneous number 93 of 2024, wherein the court had granted an amount of rupees 7,000, 8,000 or 7,000, 8,000 as
8,000.
maintenance to the respondents 1 to 3. Then counsel submits that he is a vegetable vendor, and in fact in the domestic violence case filed by the wife, an amount of rupees 7,000 is already granted. The court, without looking at the statement of assets and liabilities and the financial status of the husband, had granted the amount which the petitioner is not in a position to pay. Next one. This court has perused the order. The order is silent with regard to the financial capacity of the husband and the statement of financial capacity of the husband. In that view of the matter, there shall be stay of all further proceedings. Pursuant to the order in criminal miscellaneous and same this summons to the hand summons and shall file a memo to that effect by 21st of July. If the memo is not filed, the stay granted by this court stands vacated. In addition, issue notice to the respondents. Yes.
Please, ma'am. Obliged.
Proxy counsel for the petitioner, my lord, may be called next week, my lord.
Is there any interim order?
There's no interim order.
List this matter next week at the request of one counsel petition. Yes.
My lord, I appear for the petitioner in this matter.
Yes.
Am I audible? My lord, this is husband's petition, my lord, on interim order granted by the family court. My lord, husband is not even, my lord, completed his elementary education. He is, my lord, working on a daily basis. Now, my lord, family court has awarded interim maintenance of 12,000 and, my lord, litigation charges about 15,000, my lords. My lords may kindly see impugned order, my lord. The family court has come to conclusion that some of the amount is lying in his savings account. May I take my lord's kind permission?
Yes.
Paragraph number 12 of the internal page.
Paragraph number 12.
Paragraph number 12, my lords.
Yes.
Lord, the bank statement of the petitioner is taken into consideration. There is a regular inflow of money, that is 25,000 from so and so private limited fund transferred to Madhusudan Pujari, such as transfer some so and so every month till 2023. Further, there is sum of about 61,000 having transferred from so and so. With regard to these entries, petitioner had not even given any details. So there is a pardon, my lords?
With the
Findings.
it's going no.
My lord, my lord, this is only the facts, my lord. On these facts, that family court has now awarded 12,000 maintenance per month, my lord, as an interim.
What is your explanation?
My explanation for this is that, my lords, during COVID, my lords, the wife and the husband and wife are living separately from the year 2017. During COVID, my lord, he's lost, my lord, he has went into a loss and he sold some of his, my lord, properties and everything. This is that amount which has been shown in the, my lord, savings account.
No. What is it? Continuous transfer of 25,000.
That is what, my lord. I have sold some of the properties because I was running, my lord's wholesale, my lord, clothes business. And I sold everything and, my lord, I went back to my native place, Udupi. It is interim, my lord. None of both the parties have not filed their, my lord, affidavit.
Bank balance in Canada is 2 lakhs.
Yes, my lord, it is the property which has been sold. My lord, he is not, my lord, any business or this thing, my lord. He is, my lord.
You're having amount in your account.
That is what I made submission. This is only the paragraph. Relying on this paragraph, the family court has come to conclusion that 12,000 maintenance has been fixed. Now, my lord, I want to explain that this amount only what it has been shown. There is no any particular period has been mentioned.
6,000 within 8 weeks. No hand summons to the counsel for the respondent.
And
shall
one
file
more
a
thing,
shall
after
file a
this award, my
memorandum
lord,
or else the stay granted by this court stands vacated.
may I make another one submission? Lord, after passing of this order, I have spent nearly 2,000, 2.5 lakh towards my lord, my son and my wife's treatment also. I'll produce that documents also after passing of this order also.
We'll see once they come pay half of the money.
Oblige, my lord, grateful.
Number 10. C. Shankar Reddy.
For petitioner, my lord. I challenge the order of interim maintenance granted by family court.
How much?
6,000 and the litigation charges 10,000, my lord.
What is your income?
Income, my lord, the respondent getting 90,000, more than 90,000, my lord.
Is there anything on
She is
record?
working, she is working.
Is there anything on record to show that she is earning 90,000?
I have produced the additional documents, my lord. That
Before this
documents are
court?
not considered at additional.
For this court or the court there?
Before the family court. Additional at CH-18, my lord. Annexure K at page 73.
Come to paragraph number 11.
It appears prima facie that the petitioner is residing in Bangalore for her job purpose and she is getting reasonable salary. According to the respondent, his monthly salary is 1,70,000, which means income of the respondent more than the salary of the petitioner.
What is your salary?
According to respondent, my salary is 1,70,000.
It is not about respondent. You are here before the court.
Yes, ma'am.
You
Even
should say
she
what
has
is your
suffered-
salary. You are not denying that your salary is not 1,70,000.
No, ma'am.
Then where are the documents to show what is the salary of the wife?
She has suppressed before this for the family court matter, so that I have filed application to my lord, kindly see paragraph 5, page 7, my lord. The petitioners have both the parties filed their assets and liability by way of affidavit.
Please tell the court whether all the documents are filed before the court.
Yes, yes, my lord.
Where is that? Please show to the court.
But
Which
that,
page number?
She suppressed before family court that she is not working.
Am I not supposed to look at it? I'm asking you, please tell the page number.
My lord, page number 73, my lord. Annexure N. Annexure K, page 73. It is the ID card pertaining to respondent, my lord. That she is working as a financial analyst.
This is marked as document now, exhibit.
It is produced before the family court.
How do we know? How do we know? Land counsel submits that the court had granted maintenance of an amount of rupees 6,000 and he doesn't deny the fact that he's earning 1,70,000. But it is this case that the wife is earning and the said fact is suppressed. From the material, this court is not able to understand what is the income of the wife and hence this at this juncture, this court is not inclined to grant any interim order notice to the respondents.
Tell number
Petition is permitted to take out hand summons and file a memo. If the memo is filed, it's the matter.
Tell number
Yes,
11.
Levin.
Chandrasekhar C. for petitioner. 11.
But the salary of the husband is 26,000, not the family court has granted 7,500 rupees to the wife and 7,500 rupees to the daughter, please, Lord. But
That is how much? 15,000.
please, Lord.
Come to the order.
Page number, not the relevant, page number 28, please, my lord.
Yes.
But the petitioner number 1 and the respondent both have filed affidavit of disclosure of the assets and liabilities. The affidavit of disclosure of assets and liability furnished by the petitioner number 1 make out that she has completed SSLC and has no any income. The affidavit of assets and liability furnished by the respondents makes out that the respondent is working as head cook in the social welfare department, the government of Karnataka, earning gross salary of rupees 36 lakhs 406 as per month. The respondent in his objection statement has
So your
specifically.
income is 36,406.
That is not correct, please, not. They kindly come to the salary slip, not that is at page number 47. Not in. Not the 26,271 rupees, not. But the gross salary that has been mentioned there, not the actually. So I am drawing 26,271 rupees, please, Lord. But that apart, Lord, the respondent is working. Lord, I have placed the salary certificate of the respondent, Lord, at page number 91. I'm sorry, it is in Kannada, Lord. She is drawing 3,000.
No, where did you produce it? Did
But
you
that is
produce
I
it before
produced before the
court?
trial court, please. Lord. I have
Why-
stated in.
where is the consideration by the trial?
But that is not considered. Not that apart, Lord. My mother is suffering from the cancer. I got my unmarried sister, please, Lord, and I am suffering from fatigue syndrome for last 2 years, Lord. Kindly come to the. I have stated in my objection statement as to how I am utilizing this salary towards
Then
expenditure.
counsel for the petitioner submits that the court had granted 7,500 each respondent wife and the daughter.
Please, Lord.
Wife and the daughter. It is submitted that the court has observed that the salary of the petitioner is 36,406, but it is only 26,000. And apart from that, he has to take care of his mother and the mother who is suffering with ailments, and also unmarried sister and petitioner is also suffering with ailments. It is the case that he has produced a document to show that the wife is earning. That aspect was not considered by the court. So considering the same, they shall be stay of all further proceedings pursuant to the order dated so and so, so and so. Half of the amount and arrears also within 8 weeks, hand summons.
Till number 12,
Yes, for the petitioner.
Tata,
Milord, kindly granted time for the till 10 of July, Milord.
Huh?
This month, July 10.
You appear for whom?
I'm for the petitioner, Milord.
This is the matter on 10th of July at the request of learned counsel, the petitioner.
till number 13, Rajeshwarim.
Yes, Milord. It is upon the 24 application, Milord. Both the parties have filed the assets and liabilities. And it is not in dispute that the husband is earning 50,000 rupees.
What is the impugned order?
Impugned order is to pay every month 10,000 rupees, Milord, along with to pay the entire school fee of the children, Milord, please.
Your income?
My income is 50,000, Milord, please. 50,000.
50.
50.
Then what's the difficulty?
Difficulty is, Milord, the paying the entire school fee is very difficult.
What's the
Milord,
income
because
of the wife?
she is earning 40,000, which has been admitted by her.
40,000 she is earning.
Yes, Milord, please. I used to pay. There was
Please come to the impugned order.
impugned order at page number 41, Milord, please. Page number 41, para 16 of the order, please. The respondent has filed her assets and liabilities, wherein she has shown her education qualification as BCA, executive assistant. Date of separation is on 27/9/22. Her general income, generally monthly expenses was rupees 30,000. The details of dependents family members are shown are 2 children. Expenses for maintenance of the dependent children is shown as 10,000 per month, and 1,80,000 annual expenses towards schools and van fee. She also shown as 11,000 towards extracurricular activities, so and so. Per month towards the loan for house lease, and rupees 18,000 per month for online.
There are 2 children.
Please, Milord.
There are 2 children, 8 and 4
Yes,
years
Milord,
old.
there are 2 children. I'm ready to bear 50%, Milord, but the entire expense will be little more for me, Milord, please. Even last year also, I have paid 50% of the school fees, and she has filed the application after the academic year of the last year, that is 2024, please.
Then pay 20,000 and half of the expenses. That's how the court has looked at it.
No, my lord, the court has directed me to pay the entire school fees of
That's
both
what
the
I'm saying. You pay 20,000 monthly expenses and 50% of the educational expense.
Petitioner is also having the aged parents who is looking after. He has to look after the
You
aged
have two
parents.
children also.
I
Who will take
understand,
care
ma'am.
of them?
That is the reason I have voluntarily agreed that I am going to pay the maintenance. If
So
not,
when the wife is taking care of the entire expenses of the two children, 10,000 it will be done. And she has to pay some home loans and all are there.
well, no, that's a matter of trial because I have taken the house and it is in my name. And I
There's
left
nothing matter of trial. If you are paying the
I
loan,
left
you
the
can show.
premises, my lord. I left the house. In fact, because of the sake of the children, I left the house voluntarily. That is in my pleadings.
You
please.
might have left, but somebody has to pay the loan. Who is
I
paying the loan? You are not denying that wife is paying. When she is paying 16,000, some 14,000, what she is left with?
No, my lord, it's actually it's a.
Now
that
come
we have
to
taken-
paragraph number 16, end of paragraph number 16.
Yes, sir.
She has borrowed loan at the time of taking the house on lease and she has been paying EMI of rupees
But there is absolutely
13,100.
no document except the EMI because we have taken the house for the lease paying 5 lakhs, my lord. The question of rental income does not arise. Paying the rent does not.
We'll say 50% of the expenses as an interim order, provided you pay 20,000 to both of them.
That comes there only, my lord. Well, at least notice may be gone to other side.
Notice.
So that we can, please.
No interim order.
Please,
Notice.
Cell number
Notice to respondent. Yes.
14, window you.
Annexure A, my lords. Interim maintenance to the two minor children, son aged 17 years and daughter aged 12 years, that has been rejected by the trial court, my lords.
Notice.
Cell number 15. N. Jagadish
Short
Baliga.
request made by the husband petitioner for disposal of the MC.
Which court is this?
It is earlier it was filed in Madikeri, now it is transferred to Putturu.
Transfer to?
Putturu, Dakshin Kannada district.
Which year is MC 16?
16 is renumbered. Earlier 16, now it is renumbered as 31/2022.
No. The present petition is filed seeking disposal of MC number 31 of 2022 on the file of the family. Where is that earlier court?
Earlier court is senior civil judge and JMFC Madikeri.
Senior civil judge JMFC Marikari. And the same was later transferred to the senior civil judge. Now where is Puttur court?
Putturu.
Now it is transferred to senior civil judge Puttur.
Putturu.
Senior civil judge Puttur and renumbered as MC number 31 of 2022. Then counsel for the petitioner submits that right from 2016 the matter is pending. As such, there may be a direction to the court to dispose of the matter in a time-bound manner. The MC is filed in the year 2016 and this the same is pending from the last 9 years. And already the courts are disposing of the pending matters, the old matters in priority. This court is passing the following order. So within a period of 4 months from the date of receipt of the copy of the order.
Cell number 16.
Then the notice to the respondent is it is in the interest of both the parties. Yes.
16.
My lord, appear for the petitioner.
Yes.
My lord, this is the wife's petition for restoration of the matter before the family court. Initially, petitioner had
Please
filed.
come to the impugned order.
My lord, in page number 37 at Annexure B, my lord has it, 28/6/2024. In page 37, my lord.
Yes, please read.
I crave leave to read, my lord. Advocate for petitioner present, heard the learned counsel for petitioner, perused the records. This is a petition filed under Order 9 Rule 9 of CPC seeking for restoration of the petition filed in FRMC 2994 of 2018, MC 29, that is 2951 of 2018. In view of the Section 19(1) of the Family Courts Act, any judgment or orders passed by this court is appealable and appeal lies to the High Court both on facts and law. Hence, the petition filed by the petitioner against the orders passed in MC number 2951 dated 7/11/2019 is not maintainable before this court under Order 9 Rule 9 of CPC. Hence, the petition is dismissed as not maintainable and barred under Section 19(1) of the Family Court Act. Ordered to return original documents to the concerned as per the rules, my lord. And
Yes.
The other order, my lord, 7/11/2019 is at ink page number, which is annexure A, ink page number 20, my lord. The original proceedings. At ink page number 21, petition is dismissed for non-prosecution.
Date of order is?
My lord, MC number 2951, ink page number 21, my lord. It starts at 20. 7/11/2019.
What is the date of the order? 7/11?
7/11/2019.
So from 7/11/2019, when did you file your application for restoration?
Please, my lord. On 3rd January 2020, my lord. That is at ink page number 23, Annex B.
And from 3rd January 2019 till 2024 it is pending.
Yes, my lord. In between, from 7/11/2019 till 2020, that is about 5 months in between. Yes, it was pending, my lord. I mean, it was dismissed for non-prosecution, but it was filed on January 3rd, 2020. 6 months were pending.
MC is filed by whom?
MC is filed by the wife, my lord. It is filed on 11th June 2018. Petition
and still
for,
from 2018 till 2025, nothing is happening.
Nothing happened, my lord. Nothing, my lord.
Is it she really want to pursue this MC?
Yes,
or,
my lord. In fact, the date of the marriage is 26 June 1989. She's a senior citizen. She has gone through a lot of difficulty, cruelty, I mean, whatever, but it was very difficult for her to even get on her toes. Then she finally approached me during June 20, after this was dismissed on 26 June 2024. She
what
said,
is husband find his objections?
my lord, in 2018 he appeared and he is avoiding service in the miscellaneous number 5 of 2020. There is a paper publication, my lord, which holds the service is sufficient. It is at page number 31, my lord.
We'll see. Notice the respondents.
Still number 17.
Grateful, my lord. Grateful.
17, SP Prakash. Petitioner.
Petitioner. The
yes.
Respondent and petitioner, wife and husband.
Impugned order, where is it?
Lord, I have challenged the order of the principal judge, family court, Tumkur. Lord, the wife, my lord, in the year 2020.
If you point out at the impugned order, it will be more easy for the court to understand what it is. Page number.
Lord, 140. Page 140.
Yes. Come to the operative portion. And by exercising powers under so and so, this case reallocated to the first additional principal judge, family court, for disposal along with MC. What is this MC number 106?
My lord, there are 3 petitions, my lord. One is the wife filed, my lord, respondent in the year 2020, criminal miss number 79 of 2020.
On the file of?
On the file of principal judge. And it is at the fag end of the trial. Then, my lord, the husband, the petitioner, filed a petition under section 9 for restitution of conjugal rights in MC number 143 of 2022. Prior to the impugned order, my lord, it was pending.
So MC number 143 of
3 of
2022 is for
2020.
restitution. On the file of which court?
On the file of my lord, principal judge.
This also on the principal judge.
Principal judge.
Uh,
Then, my lord, when this was pending, these two matters pending, the wife files a petition for divorce, my lord, in MC 106 of 2024.
hmm.
24.
On the file of?
That is, my lord, made over to, my lord, after filing, it was made over to first additional judge family court.
Hmm.
My lord, even in this also, my lord, objections are filed and it is at the stage of trial. My lord, what happens, my lord, I moved a memo before the additional judge. My lord, in MC, that is divorce petition, saying that two other matters are pending before principal judge. So it is desirable that this, all the three are decided by the same court instead
When
of.
it is already allotted by the principal court to the first additional
That's, my
court, how can the first additional say that let it go to the principal court?
No, my lord, to see that, my lord, same party, my lord, three
I
petitions.
understand.
Yes, ma'am.
When already the first addition, principal has allotted to the first additional.
Yes, ma'am.
Well, the first additional will send it back to the principal, no?
No. Therefore, my lord, additional judge said he has no power to, my lord,
Correct.
withdraw or relocate. Then, my lord, before I make an application, my lord, the respondent, my lord, moved a memo before the principal judge.
Just with regard to this principal judge, family court and other courts in Tumkur, what is the pendency? Get the report tomorrow.
Yes.
Principal court and other additional courts. Yes, next.
Cell number 18.
I'm appealing to the petitioner.
For the
in this
respondent
matter,
in
my
this
lord.
case, my
Yes.
lords, I had just filed my wakalat, my lords, in the
My
counter.
lords, the copies of the entire writ petition is served to the council on 23rd of June. It's been more than 9 days. They don't file the wakalat and they're just coming today. I'm ready to address my argument on my interim application, my lords.
What is the interim application?
The impugned order, the IA that I had filed is at page 38, annexure B, my lords. This honorable court had granted me the liberty to file an application in terms of overnight before the honorable trial court.
Where is the order of this court?
My lords, I filed a memo. I filed a list of document on 23rd, if your lordships has that.
Yes.
That has the,
Page
I
number?
filed, on 23rd, I have filed one.
Page number. That has no pagination.
No, my lords, because that's the order copy which I have given your lordships.
Only order copy you have filed.
Yes, while I was addressing my argument on 23rd, my lords. If your lords have, this is your lordships.
No. Tumkur family court, principal court and additional family court. What is the pendency? Yes.
My lords, at that point of time, there was no application in terms of overnight. There was applications
Let's
always.
see the operative portion of the order.
At page 8, Roman number 7, my lords. At page 8, Roman number 7. As far as the overnight custody of the boy and vacations are concerned, the father is at liberty to move an appropriate application before the court.
Please come to your application. Where is it?
Your lords, my application is at page 38, annexure B. Your lords had already granted me first, second, and third, and fourth Monday for 2 hours, and fifth Saturday. In my application, my lords, in view of the reasons set forth in the accompanying affidavit, the respondent respectfully prays that this honorable court may be pleased to pass an order enhancing and supplementing the current visitation custody arrangement to allow the respondent to pick up the minor child after school on Friday or at 2 p.m. in case of a holiday, and for to return of custody to the petitioner by 4 p.m. on Sundays on all weekends in the interest of justice and equity.
Come to the order.
If your lords may have the order that is at annexure A, I am looking at page 35, ink page 35, my lords.
Read.
Reasons.
Read.
Point 1. The relationship is admitted. It is relevant to note that since from the beginning of the petition, the respondent has been in the habit of filing one or the other application under section 12 of GNWC. He had filed IA number 4 and they state all the IAs that I have written. At para 9, my lords, is the reasoning. Once again, the respondent has come up with an present application asking for enhancement of weekend visitation rights, even though he is aware that the Honorable High Court of Karnataka in writ petition 12734 has granted visitation rights to the father on first, second, third Saturday and Sunday. The Honorable High Court of Karnataka has specifically directed that on Saturday, father shall exercise visitation rights from 10 a.m. to 6 p.m. and on Sunday, 10 a.m. to 4 p.m. in WPs.
Yes. How can an order be like this? When the court has specifically observed that if the father wants a overnight custody, he can file an appropriate application. Court has to consider it independently, not considering the fact that already a visitation is granted. Without considering it, the dismissing this application is bad.
My lords, here the matter is, even before a routine has been adjusted to the child,
that is on the merits
another
of the
request
matter.
has been made, my lords.
That is on the merits of the matter, which
Please,
the
my
court
lords.
has to
Yes.
give reasons for that.
Yes.
By considering whatever your objections are. But court can't dismiss this application. I'll set aside this order, ask the court to consider it.
No, my lords, I want to file my detailed
What is
objections.
please tell me one good reason. This is a supervisory jurisdiction under 227.
Please, my
Everything is before this court, whatever your objections are. What objections you need to file before this court?
My
This
lords,
court is only looking
my
at
lords,
impugned order.
even the respondent is a working mother here. She also gets only weekends to spend with the child. Now he is already
That you
having.
will be saying it before the trial court. I'm not passing any other order.
Please, my
I'm
lords.
asking the trial court to consider the application.
My lords, the problem here is first, second, third, and fifth. Already he has, my lords. My lords, I may be permitted to file my objections to this
I'll also
petition.
record that it is not required.
My lords, in the meantime.
No meantime.
My lords,
Agreed by the
because
orders
by the
passed in I number 22, in GNWC number 3 of 2022.
If it could be at least
dated
time bound,
21st
my lords, in terms of this
21st April.
application.
No, let the father not show a lot of anxiety like this. Let him wait.
No, my lords,
Let
here,
him wait.
there is a
On
case where
21st day of April 2025, whereby the court had dismissed the application that's filed by the father seeking overnight custody. This is the second round of litigation. Earlier, when this matter has come up before this court, in WP number 17817 of 2025, this court has passed an order dated 18 July 2024, and the operative portion of the order reads as below. Extract from this point number 1.
My lords, there was a clarification order passed on 4/9.
Yes, and a clarification order dated 4/9/2024. After this, the father has filed this application seeking overnight custody. In the earlier order, this court has also observed that on one occasion the overnight custody is given to the father as a grandmother was coming, and that aspect cannot be the basis for the court to grant overnight custody, and the court has to independently deal with the application. Now, when an application is filed by the father seeking the overnight custody, the court, by way of the impugned order, has dismissed the petition. This court has perused the order that is passed and the reasoning that is given by the court. The court simply says that discusses about the earlier applications that are filed, and the order that is passed by the court in the red petition, that is 12734 of 2024, and also discusses about the visitation that is given to the father. So the court feels that the court do not find any merits in the application and accordingly dismissed. Next paragraph. Learned counsel appearing for the petition of father submits that when this court has given the liberty to the father to seek overnight custody, the court ought to have considered the application on the merits of it and ought to have passed a reasoned order. It is submitted that in this case, they have filed an IA seeking the visitation, seeking the overnight custody, and the same may be considered. Next paragraph. Learned counsel appearing for the respondent so and so submits that they have filed wakalat recently and they want to file their objections. And it is submitted that the mother is also a working lady. If the overnight custody is granted, she would not be in a position to spend time with the child. The court, considering all these aspects, had rightly dismissed the application, and there are no grounds to interfere with the same. Next para. Having heard the counsels on either side, produce a material non-record. As per the order passed by this court, dated so and so, a liberty was given to the father for seeking overnight custody, and the court has to independently deal with the application, notwithstanding the fact that the court has already granted visitation to the father on one occasion. When such an application is filed by the father, the court has to discuss the feasibility of granting the overnight custody, whether it is in the interest of the minor or not. But the reasons that are given by the court are not at all convincing, and in that manner, the court cannot cannot dismiss the petition. Court has to look into what is the requirement, whether there is any requirement for granting overnight custody in the interest of the child, and how the visitation was going on. All these aspects should have been discussed by the court. Then coming to the submission of the learned counsel for the respondent that they want to file their objection. This is an application that this court exercising the supervisory jurisdiction under 227, where both the parties have filed the application as well as objections to the application, and the order of the court is before this court. In those circumstances, the court do not require any objections to be no objections are required to be filed. And when all the material is before the court will not look into any other material which is not filed before the court. Then in that case, no objections are required, and the submission of the counsel for the respondent, this court is not considering. Next para. In view of the above discussion, as the court had failed to consider the application in its proper perspective, the order dated so and so is set aside, and the trial court is directed to consider the application on the merits of it and shall pass a reasoned order within a period
My lords,
of
in fact, my
within
lords,
a period of 2 months from
in the
date of receipt
continuation
the
of
copy
the said same paragraph, there is a mention of already summer, winter and Dasara overnights that I've been enjoying. With that statement also, still the order was read. If that overnight thing may be kindly mentioned.
No, that court will decide independent and not have any
My lords,
observation.
some time bound on this application because
Is it
already
2 months? Yes.
Much obliged, my lord.
19.
Next.
For admission, cell number 19. E. Sukumaran for petitioner. N. Sriram Reddy.
That's fine.
Yes.
Lordship, this is a husband's petitions revision.
Please come
before-
to the impugned order.
Yes, ma'am. It is the operative
Come to
portion,
the reasoning part.
operative portion of the orders, my lord.
No, come to the reason. Paragraph number 9.
Yes. Point number 4. The reason the London Council for the Respondent has drawn my attention towards the 11th provision of the CRPC Evident Act, Constitution of India, along with the citation submitted that the petition is not maintainable, since the respondent has seriously disputed about the maintainability of this petition. I have taken this point for consideration as the first. The petition is the wife of the respondent. She is claiming a maintenance from the respondent for alleging that she is unable to maintain herself and that the sufficient reasons she is residing separately from the respondent and the respondent having a sufficient means to capacity to maintain herself and her daughter and refused to maintain them. She has pleaded as per the terms of a memorandum of settlement in criminal miscellaneous number 19 for 2011 on the file of MMTC in first. The Bangalore, the respondent is paying 15,000 per month, but the said amount is not sufficient for maintaining herself and her children. She has pleaded that she is spending nearly about 40,000 per month, excluding education expenses of the children. Herein, the respondent has raised a different plea regarding the maintainability of the petition. According to the respondent, this petition is not maintainable in view of the settlement between the parties in criminal miscellaneous number 19 for 2011. On that, without impleading the minor daughters, and the petition cannot seek a relief against the respondent in respect of the said minor daughter. And that concept, the rejudicate of a law of estoppel, is inapplicable to the present case. It is a further submitted that the settlement of criminal miscellaneous 19/2011, the petition has withdrawn allegation against the respondent. As such, the present petition filed by the identical allegations, a maintainability of the background of and a letter considered to the plea of the maintainability of this petitions raised by the respondent. The respondent has not disputed the relations between himself and the petitioner as well as the patient's, the twins' daughters to the notice that petition had filed the petition under provision of the Protecting a Woman's Domestic Violence Act and on the file of the MMTC first Bangalore in criminal miscellaneous 19 of 2011. The petition has produced the certified copy of the order sheet and the said as for the exhibit P4, the certified copy of the memorandum of agreement entered between herself and the respondent before the Bangalore Mediation Center. In the said case, as for the exhibit P5, it is noticed that the terms of a memorandum of agreement of a said the case was dismissed on 24/2011. In the exhibit P5, the memorandum of agreement of this court noticed that the Bangalore Mediation Center, during the course of mediation, the parties have resolved their disputes, agreed for the settlement of the certain terms and condition. The first condition was that the care of the custody of the minor daughter of Andrea Miriam Stanley and Annika Elizabeth Stanley shall be with the petitioner here. In the second condition is that the respondents agreed to deposit somehow rupees 50,000 towards the welfare of the children, amounted in as a minor maintenance at Access Bank, Coxstone, Bangalore branch before 10th of each of a calendar month. The liberty was given to the petitioner mother to withdraw the said amount to utilize the same for the welfare of the minor children. The third condition is that the respondent has agreed to give the residential flat apart from situated at Parkati Township next to Vincent Alotti School of Babuspalaya, Bangalore 43 in favor of his minor daughter on before 30th June of 2011. It appears that the pleading is an evidence of parties. The respondent has complied with the condition number 2 and 3 as a recital of exhibit P5. The memorandum agreement, it is evident that the record of the respondent has been deposited 15 per month, regularly gifted the residential apartment in favor of the minor children in the petitioners on 15/6/2011. Now the question whether the disposal of criminal miscellaneous 19 MMTC number 1 Bangalore attracts a concept of rejudicata on pursuit of section 11 of CPC makes it very clear that the order attracts the principle of rejudicata. The matter must be heard finally decided by the court of former suit, the proceeding in respect a present case. It reveals from the records that a criminal miscellaneous 19 of 11 was not finally decided on merit. It was dismissed by the above said court as per the memorandum agreement between the parties. Further, the criminal miscellaneous 19 of 11 was filed under the relevant provision of the Protection of Women from Domestic Violence Act, but the present case has been filed provision of CRPC. Apart from maintenance, there is other issues. The determination of a criminal miscellaneous 19 of 2011, the present case, the maintenance is only issue determined. Further, the criminal case 19 of 2011 was disposed of since the respondent voluntarily agreed to pay the maintenance to the children and give the residential apartment to them. It is noted that the payments of maintenance gifting the apartment to the children was not as per the direction of this court, but the same has been a mutual agreement between the. Therefore, I am of the view the principal rejudicata cannot be made applicable to the present proceedings. The next ground urged by the respondent regarding the applicability of law for estoppel, section 1 and 5 of the Evidence Act state that when one person has in a declaration, act, or omission intentionally caused, permitted another person to believe things to be true and act upon such a belief, neither the nor his representative shall be allowed, if any suit of the proceeding between himself and the persons of representative to deny the truth, that being in the present case in my hand, the petitioner has not denied the memorandum of agreement of criminal misdemeanor 19 of 2011. Further, she also ought to deny the payment of 15,000 per month by the respondent to the minor daughter. Further, she has also not denied the gift of the residential flat apartment to the respondent. Her contention that she records a sum of rupees 40,000 per month towards the maintenance herself and her two children, a sum of rupees 1 lakh towards the expenses education her minor daughter, and that she is not capable of bear the expenses. The plain reading of the above said, section 1 and 5 of the pleading that the evidence petition clearly establishes that the law of estoppel does not bar the present petition. Therefore, I am on the view that the law of estoppel is not applicable to the present case in my hand. It is to be noticed that Exhibit P5, the document, there is no specific clause that the petition shall not make a claim for enhancement of maintenance, additional maintenance amount, a further and a change of circumstance. Since the cost of living have increased and the scale of has been changed, I am of the view that the amount of maintenance decided in 2011, a petition under children cannot let the simple, respectable life in the year of 2017. I hold that voluntary agreement respondent for the payment of maintenance, the children cannot become estoppel of the petitioner claim additional maintenance to herself or children. Therefore, I am of the view that the present pleading of the petitioners, the law estoppel will not act as a bar. The landed counsel for the respondent has produced the citation ILR 2016 pair 14 and 16 Sri Surendra Naik and the Sheriff ILR to the Karnataka 3355 Parsuram and the boy, the Ramachandra, etc. I have pursued the said citation and consider the ratio laid down in the case of the background of the present case in my hand. I am of the humble view that the ratio laid down in the above case is not applicable to the present case.
Yes, Mr. Counsel, I've seen the judgment.
Yes, madam.
What are your submissions?
My submission, my lord, the foremost, the finding of the London trial judge is an erroneous. For simple reason is that the provision under 125 that the.
What do you say on that? How can you file an application under 127 when the maintenance is not granted under 125? That is a valid ground.
But there is a clear citation in this regard. We can also approach the Honorable Court.
No, it is not that he cannot approach. You could have filed an application under 125.
125.
But you have not filed under 125. You have filed under 127 seeking enhancement of the maintenance.
Yes.
That is granted in the Domestic Violence Act. The provision, the procedure that is adopted under the Domestic Violence Act, 125 CRPC, there are two different provisions.
There is a provision.
And one more thing, because you had a maintenance under Domestic Violence Act, it will not stop you from filing or seeking maintenance from other provisions.
Yes.
But how can 127 be applicable?
My lordship,
once you are granted maintenance under 125 CRPC, you seek enhancement under 127.
Well, even 127 is concerned. There is no specific provision to say that. Even after 125, we have.
For example, in MC, you are granted some maintenance. So can you say that I'll go under 125 and seek enhancement of maintenance? What is granted in the MC?
That's why it is clearly interpreted in the decision.
Please pass on the decision. Yes, which paragraph?
Could you say a copy?
Give him also a copy.
Give me a copy, Sriram.
Copy is not here.
Which paragraph?
Copy is not here with me.
You don't have a copy?
I do not have a copy.
Only one copy we have.
No, you have a copy now, or only this is the copy?
Only one copy
Only
we
one
have.
copy. We thought we have. It is under citation.
Where you have two copies, please rely on that judgment.
Yes.
There cannot be any judgment saying that you take maintenance under Domestic Violence Act, file a petition for enhancement under 127. What it says is, in spite of having a maintenance under Domestic Violence Act, you can have maintenance under the other provisions. That is in addition to it.
Even my lord, at this juncture, my lord, even in the DV Act, the maintenance is about 15,000 per month. It is continuously, it has to be applied. Even in spite of if you file this application or not, he has to pay.
That is what I said. 125, see, Domestic Violence Act, you had 15,000.
Yes.
If you feel that you're entitled for maintenance and not able to maintain yourself, you could have filed an application under 125, but not under 127. Because you file 127 for seeking enhancement of maintenance that is granted under 125. No application is filed under 125. No, without going into what is the provision and other this thing, court has in detail discussed about your income and other things.
Correct.
You are working as a doctor and your income is 1 lakh per month.
What happened due to this litigation, the doctor has lost his job. And she's a MA and she owns a beautiful properties and others.
Let's forget about her maintenance. What about the maintenance to the children? What about their educational expenses? Who will take care?
My lord, I have paid, I have been paying, they have become attend majority now. Now they are 23 years.
Correct.
23 years,
no,
my
no,
lord.
No.
Yes,
Now, this application is, that's from 2018 to 19 till completion of their education.
Yes.
When did they complete their education?
My lord, what happened? According to me, they completed about about 20 years itself. About 20 years itself. Now what?
What 20 years?
Yes. What they're doing?
What is 20 years? I don't understand. There you are saying that now they are 23 years old.
No, the 23 years present.
Yes.
Yes, present.
Then they must have completed at 21 or 22.
No, they were.
That is a year ago.
No, according to me, what has happened? When they were litigation.
What is
and what their qualification? Where they residing? What is their education? They were not informed to me, my lord.
One daughter is doing LLB. Other daughter.
What is her age? Age
22. They crossed 22. They about to reach 23.
Both of them. There must be a gap between both of them.
Twin daughter.
Twins.
Twins. Okay.
One daughter is studying final LLB. And other daughter is doing.
Where are the educational expenses?
I gave the message.
Where are they?
Memo.
Only yesterday.
Yes, this
gives
that anyhow. Where is that? How can you say that is wrong when you paid the?
It is here,
my lord.
Where is that?
It is here. Please give.
Remember, there is no enclosure has not been there. It has not been informed till the pendency of this case. Even after the orders are passed.
Why are you now? Why are you?
It has not been made a mention. Can I imagine myself, my lord?
The children.
My lord, I have given one apartment which I had it. I have given to them. I have registered and given to them. As for the terms of that, what happened after the children have completed their education, my lord? And I do not know what about, and they did not even allow to see me and all this thing. No information.
So file GNWC case, you have withdrawn. That shows that you have no intention to have
my
the
lord.
custody.
Yeah, my lord. That is a good question. What you put me, my lord. My lord, here the settlement about the settlement arrived about the mediation. Once they have agreed, they can rake it up again, my lord. Just see the settlement, my lord. Annex 43, my lord. See what happened there.
My lord, this is the
43,
expenditures for this year, my lord, this academic year.
That I don't know all those things. He should tell us, he should inform us, the father, no. The mother doesn't inform.
My lord,
informing you now.
Even the
now
father,
he is informing, my lord, of the court.
Please come.
My lord,
the father
educational expenses of the children from 2000,
18.
where is that operative portion of the order, page number? The educational expenses of the children from academic year 2018-19 till now shall be placed before the court with the land counsel appearing for the mother, and the same shall be served on the counsel for the petitioner husband for the father in advance. List this matter on 8th of July. To the- Yes, next.
Number 20.
On the last occasion, I have submitted some calculations, Your Lordship, for Your Lordship. So as to the total amount, how much the amount it will be.
Yes, Marital.
And
what
Your
my
Lordship.
learned friend has,
Of calculation is filed by the respondent.
yes, Marital. Last two payments have not been considered by
Mention.
the respondent side. That is amounting 40,000.
No.
Two
mention.
payments, I mean, 20,000 each have been paid. That has not been considered in their.
How are you paying that money?
By check and all only. It is on record before the trial court also.
Then you can.
Yes, I applied for the certified copy also. Yesterday only
Online it is not available.
it's available.
Then why don't you
Anyway,
take the
it's
printout?
collected certified copy also.
Lordship.
Another 2-3 days I will get it.
No, why it is when you have, you can have a printout, you can show
Yes.
it to the court. Why do
Yes,
you want
ma'am.
because he cannot deny it when something is.
Yes,
available
I am
online.
also not denying. Only two payments he has not considered.
According to you, what is outstanding?
Outstanding, Your Lordship, now it is 2,86,250.
So.
So
now
according
even-
to me,
Even considering that 40,000 was not included in that,
yes,
still you are supposed to pay 2,46,000.
yes, certainly.
When are you
I am
going to
filing the application also for seeking extension of time for payment of this.
When is the
Promptly I paid.
When
Now
is,
I prepared.
passed by the court?
Yes, madam. I prepared the application and file it in the office only.
1 minute.
Please.
Lordship, the calculation.
So order is passed on 13/12/2021.
Yes.
What is the extension of time now?
Yes, regularly I am paying 2-3 months back. I am not keeping well. It is also on record.
Then what will
And
the
shortly
court-
I will everything I will clear. Promptly I paid the said amount as directed by this honorable court.
What we will do is we'll vacate the order. Whenever you have the time, you can.
No,
pay.
madam. Shortly I will pay it.
He will execute the order.
I am filing the application also for extension.
You file it.
I served the copy also. And kindly have it another 2-3 days, madam.
This writ petition of 2021.
I will come back with certain instructions and all.
What is that according to you? 2 lakh?
2,86,250.
A memo of calculation is filed stating that an amount of rupees 2 lakh 86,000.
250.
2 lakh 86,250.
That is as on the date of Your Lordship, 26/6/2025.
As on
26/6/25.
26/20/25 is due. Land counsel for the petitioner submits that an amount of rupees 40,000 that is paid.
That is also calculated. I have
That's his contention.
My
An
contention.
amount of 40,000 that is not shown in the calculation memo. Even if the said submission of the council is taken into consideration, still an amount of rupees 2,46,250 admittedly is due from the petitioner. When an order of stay is granted by this court on the condition.
My interim 1 week time may be granted. I will clear it and come back.
I'm going to pass the same order.
Please.
That the what is that? Passed, stay is granted by this court on condition. The petitioner now submits that he is going to file an application for extension of time, and he seeks some more time to deposit the amount. The said submission, this court cannot consider. List this matter on today it's first.
10 days on.
Matter on 10th of July. By the time, if the amount of rupees 2,46,000 is not paid by the petitioner, the stay granted by this court stands vacated automatically without further reference to the court.
Please. Public.
Case next.
Case number 21,
Bring for the- no.
Ahmad Tahir.
Lordship has given issue directions to appear the husband and wife to be the court.
Both are present. Respondent is before
Matter
the-
about,
Lordship, it is a miscellaneous petition under 125 was filed by the wife. It is with the relief to the daughter was granted. For wife, it has been rejected. The ground of rejection was that she has rejected the husband. And
no, the other day you were saying that both of them are ready to.
Yeah. Wife is ready. Wife is ready
Also
before the
ready.
court, Lordship.
That's why he has filed the restitution of conjugal rights. It was decreed, but even though she has not.
It was,
When is she joining? Today itself
Yes.
she's joining.
but whenever Lordship,
Today
the
only.
issue is what? There is also DV cases pending. There is issue of mother-in-law. If he maintain a house, separate house, tomorrow itself she can join. She doesn't have any issue with the
Yes,
husband.
Today itself, is ready.
Alternate,
What?
No. What he's saying is that mother-in-law should not be there.
No. He is the only son to mother-in-law and father-in-law.
So if you say restitution can't be on your conditions.
No,
your
it's
terms.
restitution, Lordship. The
Is the-
difficulty she has to remove, Lordship. If we cannot go there and where we face difficulty, again the same process will start. The only issue is that there is no dispute between the husband and wife, fundamentally. Only the issue of the in-laws.
Mother-in-law will be good with you.
No, certainly, Lordship, there. We don't know the intricacies in the relationship.
No, how
If-
can you say when mother-in-law,
But
why should
some few days, if we keep a wife separate, after that he can win over the wife and she can join. See, it's all about the attempt. If they are not making attempt properly.
court cannot pass that kind of.
No, I am not requesting the court. If that some arrangements will be made. Some arrangement will be made, it will be convenient for her.
What is he doing? What is his financial capacity?
He is a traveling agent. He has sufficient income, more than 1 lakh income is there for him. He is paid only paying 5,000 rupees
10 to 15,000 earning. He is a private driver, auto driver, rickshaw driver.
All the records we have produced it, Lordship.
Rickshaw driver.
I am not on the married. My only issue with if Lordship can refer the matter to the mediation or any conciliation, let them make an effort, mediator let to make them under attempt.
No, we'll do one thing. Let the wife go and stay with the husband. If she has any difficulty, then we'll think about it.
Please.
I'll just take instruction from the wife.
Call the next matter.
Case number 22,
Husband's petition, my lord,
Rohit Sequela, petition.
125 proceedings, my lord. Whereas the trial court has awarded from 1/4/2016 till 1/4/2025, 10,000. And thereafter, my lord, 40,000. But my contention is that, my lord,
What is that date you're saying? From 1/4?
1/4/2016 till 2/4/2025, 10,000. From 2/4/2025, 40,000.
40.
40.
What is your income?
My lord, my contention is that, my lord, 125 CRPC, my lord, states maintenance of the wife. My lord, my contention before the trial court throughout was that, my lord, there was no valid marriage at all. My lord, in the year 2004, my lord, petitioner and the respondent got acquainted with each other. Thereafter, my lord, the petitioner herein is a Hindu. My lord, she belongs to Christian community. Petitioner was called to Sagara, my lord, to meet meet her uncle, who is a priest in the church. My lord, there he was asked to sign some documents, which were in Kannada. He signed, my lord. They said that, my lord, it is an agreement, my lord. And thereafter, my lord, he convinced them that marriage should be as per Hindu rites and customs. They agreed for that. And once again, he was called and they demanded that, my lord, to show to the society that there should be a marriage in the church. My lord, he has to agree for taking some photographs and blessings by the priest. My lord, he agreed for that. Photographs were taken and, my lord, there was a blessing.
Why so many times he's agreeing?
My lord, there was a love affair between them, my lord, and he agreed. Thereafter, my lord, since 2007 onwards, she vanished, my lord. Till 2012, she was not there.
So,
later, it was found out.
Whatever is the reason, you are accepting that under the Hindu customs and the Christian, she got married. Both of you are married.
For valid marriage under Christian Act, my lord, there is a issuance of certificate after solemnization.
What about Hindu marriage?
There is no such certificate.
So you're accepting that it is done.
My lord, it is not done, my lord. If there is no certificate issued by the,
Because the court, while under 125 CRPC proceedings, will not go into the deeper into those issues as if like the court is deciding a criminal case. With the preponderance of probability and with your own submissions, there is a marriage.
my lord, I am inviting my lord's attention.
We are not dealing with any MC, whether there is a valid marriage or not. There is a cohabitation, you have been
There is no
deciding
cohabitation,
together.
no cohabitation at all.
When is the marriage according to you?
My lord, 2005.
You are saying that
According to them, my lord.
2007 she vanished.
She vanished until 2012.
What is happening? What
My lord,
happening?
she was living with somebody else, my
Please
lord.
please come to the impugned order. Yes.
Reasons, my lord, from 58.
Yes.
In this case, the respondent has disputed the marriage between petitioner and the respondent. To prove the marriage between petitioner and the respondent, the petitioner has relied on her own oral evidence and evidence of PW2 to PW4. PW2 is the brother of the petitioner, PW3 is the mother of the petitioner, and PW4 is the uncle of the petitioner. That is brother of PW3. PW2 to PW4 is in their chief examination have deposed that on 26/1/2005, the marriage between the petitioner and the respondent was solemnized at St. Anthony's Church, Hosanagara, Shivamogga district, and they had participated in the marriage. PW2 to PW4 have further stated that at the time of marriage, other persons have also gathered, and immediately after the marriage, there was a reception at the Gayatri Mandir, Hosanagara, and public were invited for the reception. On 22/12/2004, engagement was performed at Bangalore in Shanti Sagar Hotel. Even though the respondent has disputed the marriage, he has taken different contentions that there was engagement in the month of December 2004 between the petitioner and the respondent. Thereafter, in the month of January, he was called to the petitioner's place of petitioner, and petitioner's relative, who is the father of the church, took his signature on some documents which were in Kannada language, and he was unable to read, and finally it was told to him that they are formalities. Once again, in the month of January 2005, he was called on the guise that father of the petitioner was suffering from ill health, and at that time some photographs were taken and his signature was taken. PW2 in his cross-examination has produced exhibit P11 to P31 photographs, and he has specifically deposed that those photographs were taken at the time of marriage. At the time of marking those photographs, the advocate for the respondent has not objected. During the course of cross-examination, PW2, it was suggested to him that those photographs are created. Exhibit P18 to 31, photographs are required to be considered along with the specific defense taken by the respondent that.
What is the name of the respondent?
My lord,
Janit, my lord.
Janit Flavia Sequeria.
She belongs to Christian community. Para 14, my lord.
In the Domestic Violence Act, already 10 lakh compensation was directed to be paid.
Yes, my lord.
Did you question it?
My lord, it was questioned, my lord. It has
What
challenged
happened to
before
that?
the appeal is pending, my lord.
It is not 10, it is 15,000.
15,000.
Yes,
My lord, the lordship may kindly spare a look at para 41
yes, I've seen.
to disbelieve the evidence of PW1 that she has no source of income. Nothing is on record. My lord, she has said, my lord, that there is no income at all. The lordship may
He has filed a statement of assets and liabilities.
not filed, my lord. The lordship may kindly see, my lord, page number 95. Her yearly turnover is, my lord, more than 30 lakhs.
Where is it, 90?
95, page number 95.
What do you say on this?
Lord, this
Asset
is
and
the
liability. Asset and liability were filed, your lordship. I'll just look at.
income received. 30 lakh 32,000. But whereas she has suppressed the.
Does this belong to you, this company outlet?
We are not been served a copy, your lordship.
She has 4 boutiques, my lord, in heart of.
All this evidence is not before the trial court.
She has not stated anything before.
No, you also. No,
No, I didn't know. I came to know recently, my lord. Recently, I came to know all these facts, my lord. Otherwise, I would have produced before the trial court.
Then by way of an appropriate application, this should be done. Just like that, what is not produced,
Please, I
you
understand.
can't file all
I
that.
understand.
Yes, no stay, will not grant stay, file all your documents. The petitioner shall serve the copy of the petition on the council appearing for the respondent. And if any additional documents are there, by way of an appropriate application, that shall be filed. Does this matter after 2 weeks?
Obliged.
Who so and so undertakes to file wakalat?
Date may be given after 2 weeks.
It will come on 16th.
Obliged.
Much obliged, your lordship.
Yes, next.
Till number 23, here in B group. Then Gautam, petitioner.
I was
Esther
happy for the
Pratima.
petitioner.
Look, this matter, if your lordships recollect, it was in the chamber for quite some time. Well, it's during the settlement talks, the child was sent by the mother on your lordship's intervention that the parties could settle the matter. But however, that became this thing, and last time what happened was, since the matter could not be taken up, I believe they made a submission saying that let the interim visitation rights continue as it was. Now that created a confusion. Plus, if they are ready to settle, today also she is, but that's gone.
No. If the boy is comfortable, why are we making it? No, if the settlement goes, boy will go. If the settlement is not happening, boy will not.
No,
go.
Milas, it's not that. In fact,
then we have to assume that or presume that the mother is not, not letting the boy meet the father.
Milas, in fact, the boy can be kept present before the court. In fact, I think probably the settlement has not happened because they think the boy is not ready to come and stay with the father. The father does not make any efforts, which is a fact. He does not make any extra efforts to come, take the child, or talk to him in a nice way. He has to build a bond. How long can he keep depending on the mother to force the child and send?
You know, even forcing the child is also in his interest. What is wrong in it?
Plus, how long can she keep doing that? At the cost of the boy rebelling against the mother? But why should she do that? She tries and does that, and it has been happening.
She should do something in the interest of the boy.
Exactly, Milans. That's exactly what is happening, which she has been doing.
If the boy is not understanding something, then otherwise also he should be made to understand that something is good for him.
And she is making all efforts. And here during the settlement talks, they go make sure a warrant is issued against the mother, where she has to run to the court and take a bail. How fair is that? Why would she?
The instruction I've received is the text, what has been transpired here, my lords. In this text, there are places where they say that, like, though he's making attempt, boy is not receiving the video calls, and then he informs the mother by saying that, like, please tell the boy to, like, somehow connect it. But then she insists, like, he himself is cutting the call, so I can't. So it's a very complicated situation, my lords. And with regard
So what
to,
do you expect the court to do?
my lords, with regarding to the interim arrangement, what?
No, court will pass the order. Boy will not come. What you will do?
Lords, I shall keep senior counsel present, my lords. Any short date may be given.
Plus, this day was fixed because they wanted this day. In
Senior
fact,
counsel has
Please,
asked
my
for
lord.
it. How
Personal
can you, every time the matters can't be adjourned like this?
I am.
in fact, from past 3 months, he's not even made any payment of maintenance
I'll
amount.
not pass any interim order with regard to visitation.
Please.
Nothing. Let's just matter on 17th of July.
Much of.
Then number 24, Deepa J for petitioner.
I'm appealing for the petitioner, my lord.
Ms. Swami Gowda.
Yes.
My lords, I'm filing a report just through an affidavit. Lordships had granted overnight
On
custody.
13/6/2025, after the school hours, the father can pick up the child from the school, drop the child back on 14/6 evening at 5 p.m. Any inconvenient authority shall be informed to the mother, and if the boy insists, he shall be sent back to the mother. The earlier order with regard to maintenance, the father shall continue to pay.
My lords, I'm filing one affidavit.
I'm so sorry to interrupt you, Lords. I'm extremely sorry. It was reflecting on the website, he quotes this thing, that the interim visitation is continuing. Let that
Now
be
I
just
passed an order.
gratefully.
I just said nothing, just list the matter on so and so.
My lords, in a form of an affidavit, the father stated how the overnight has gone. And I have also produced photographs and the communication. In fact, if your lords may kindly have, at page 4, the father in fact communicated to the mother and requested the mother to give the schedule of the child after 6 p.m. because the father has always spent time with the child only from morning till evening. But the mother chose to not respond. The father has taken care of the child extremely well, and the child has been extremely comfortable with the father and his family members. I've produced photographs also. This was the first overnight that the father enjoyed after the mother left the matrimonial home with the child.
What do you say?
My instruction says that, my lord, after the child came back from the father's house, my lord, for 4 days, my lord, in the night, in the middle of the night, my lord, the child wakes up with a fear and says, "Don't beat, don't beat, don't beat me." But that's what the instruction that I have received, but which I did not wanted to bring to the notice of this court, saying that this happens in all of this thing. For 4 days, the child continuously did that, and now the child is now coming to the normal this thing. But I thought that, my lord, let them build up the bond up and this thing, my lord. Now they are filing a report. Then I'll also file a report saying that this is what has happened.
Allegations in the air, my lords. Constantly allegations like this. In fact, your predecessor earlier, my lords, Honorable Justice Pradeep Singh had met the child and the father and the mother and noticed that the child is extremely comfortable with the father. Therefore, their lordships granted further interim order.
Did you ask the boy why is he, what has happened there? Did he tell that father did something to him?
No, I didn't ask her, madam. Morning I called up because saying that the matter has been moved. I don't know the reason. What has happened to find out that? Then she told me that this is what has happened.
Ask her to come there tomorrow to the court.
Yes.
Let the child not be there. Let her come and tell what it is.
Yes, ma'am.
Tomorrow. Yes, next.
Bill number 25.
Here for the respondent, my lords.
Mohan for petitioner.
I appear for the
The
petitioner.
respondent mother.
My learned senior is on his feet. If the matter may be passed over, I request the court's indulgence.
No, pass out today, tomorrow. Tomorrow.
Certainly, my lords. Tomorrow.
Instead of tomorrow, can it be following Monday? Only requesting.
My lord,
Because this week I have other matters which were slightly tied up.
I'll defer to my seniors and my lord's convenience. Tomorrow works for us, my lord, but as per the my lord's.
Monday. We'll take up on Monday.
Certainly, my lord.
Monday.
7.
Sorry, apologies.
7,
Monday
7.
or yeah, Friday. 14. Friday.
Call the next
My
one.
lords,
Apologies. 4th Friday. If
Yes, Friday.
Friday. Friday is great.
Right. Yes, 27.
Post. Bill number 25. Sergeant. List number 2. B and Passed over in.
Where is he?
Cell number 21 passed over in list 1.
Where is he?
Muhammad Tahir.
Call him. He must be outside.
Please.
Yes, next matter.
Yes, list number 2. Provision court matters. Cell number 1.
Yes, why is it listed for dismissal?
Not claimant appeal for enhancement. Already settled before Lok Adalat, another 2 connected matters. And giant memo already signed.
Already signed.
Kindly refer to Lok Adalat, all 3 matters.
It is submitted that the connected matters, what does that mean? Give that the connected matter MFA number 8125. No, MFA number 8119-8167 of 2023 is already settled before the Lok Adalat. Hence, when counsel submits that this matter also may be referred to the Lok Adalat, registry is directed to place the same, delete from the caption for dismissal.
Cell number 2 for orders. Harish Babu KN.
Await service of notice, less this matter after service.
Cell number 3. Cell number 3.
A week's time is granted.
I appear in the connected matter.
Which one?
In the serial number 3.
3. In serial number 3, MFA 2817, a week's time. You take notice for respondent?
Please. The Lakshmi Shra.
To respondent for the first. How many respondents are there? Look at the file. If you are there, then no notice is required. No process is required.
I appear for case artist.
Yes. Must be one respondent.
Only one respondent.
So Mr. So-and-so, Mr. Lakshman Rao.
Lakshmi Shra.
Lakshmi Rao takes notice on behalf of the respondents. Call for the TCR. Yes.
Awaiting service in the connected.
TCR has already been called. It's awaiting.
No, it's awaited. The registry should make a first to get the TCR. Just 4.
Cell number 4.
Take the memo. Memo for withdrawal. Appellant is the claimant. What is this? To withdraw the appeal and file a writ petition and to return the certified copies. Common order on IA number 1 filed under 5 of the Limitation Act. Interlocutory order. The petitioner, MFA is filed seeking to withdraw the memo is filed seeking to withdraw the appeal and give liberty to file a writ petition before this court. The petition is dismissed as withdrawn, giving liberty to the petitioner to avail the appropriate remedy, and the registry is directed to return the certified copies. Yes.
Sale number 5, hearing on interlocutory statements. Sale number 5. Pradeep B for petitioner.
Yes, no representation. This is matter on 22nd of July.
Sale number 6. KT Madhu.
IA 1 of 25 is filed, seeking substituted service of notice on respondent number 1. And the same is ordered, and petitioner is permitted to take out notice in so and so, mentioning the date of hearing as so and so. Yes, 7.
Much obliged.
In 7, notice to the respondents. Then
Sale number
case artist matter is there.
I appear for appellant.
No, yeah, we can issue notice to him, to ask him to take notice. Lakshmeswar Rao is the only counsel for RTC.
Case Dabalis.
Oh, some other counsels are there. Note the notice to the respondents. Next.
Sale number 8.
Much.
Sale number 8.
No representation. This matter on 29th of July.
Sale number 9.
Serial number 9 appear for the respondent, my lord. Actually, my lord, this matter is already admitted on 21/10/2024 and substantial question of law also framed.
Is it admitted?
Yes, my lord. 21/10/2024. Substantial question of law also framed. And my lord, in this case, because of the serious condition of
1 minute, Mr. Counsel.
21/10/2024, my lord.
2110.
Substantial questions of law framed.
This matter has come up before the court for admission, and on 21/10/2024 itself, the appeal is admitted. This is matter for final hearing.
Finally, one minute, my lord. I have filed an application for early hearing because of the serious condition of the respondent.
Where is the IA?
IA allowed, my lord. IA allowed, and today it is posted for to file the respective council's contentions, my lord. But as per that, I filed my contention before this honorable
What
court.
is filing contentions?
Respective our contentions of both the petitioners and
arguments.
respondents. Yes, my lord, in that way. And I filed my contentions like before this honorable court, my lord.
Forward to me, I will file contention before tomorrow, my lord.
Tomorrow, it may be taken up tomorrow. It's a matter
In this
urgent,
case,
my lord.
the matter
Because-
day after tomorrow, land counsel for the respondent shall serve the copy and the counsel for the petitioner. Yes. Next 10.
Sale number
Day after
10.
tomorrow, my lord.
Day after tomorrow.
Sale number 10.
Immensely obliged.
10.
Ashok and Patil.
I appear for the appellant.
Yes.
This is insurer, my lord's appeal on the ground of, my lord, there was no permit.
No permit.
No permit at the place of accident, the vehicle was, my lord.
Pay and recover will apply.
Pay and recover will apply, my lord, it is not applied here in this case.
So then amount has to be deposited complete.
But I will deposit, my lord. And my lord, the second ground is,
So no, what I'm trying to say is
Yes.
no 50% then. Ultimately, your liability is there.
no, my lord, the other ground is with regard to quantum, my lord. The,
How much is the amount granted?
my lord, kindly see, my lord. The amount is 9,83,100.
9,83,100. And according to you, how much it should be?
According to us, my lord, 50% ought to have been deducted since, my lord, the
No,
claimants are majors.
If we do that, how much the amount?
Well, it's 5 lakhs I deposit. Lords.
5 lakh.
Yes.
Land counsel for the appellant submits that as on the date of accident, the accident had taken place at a place where there was no permit to ply the vehicle.
Yes.
The court had failed to deduct, it's a case of death,
In case of death.
failed to, is a bachelor.
No, my lords. The claimants are major sons and daughters. That's how, my lords, I am saying that, my lords, the 50%
That
should have.
the claimants are not dependents, and the court ought to have deducted 50% of the amount. It is submitted, the 50% of the amount, considering the submission of the land counsel. This court names it, there shall be stay of all further proceedings on the condition that the appellant shall deposit an amount of rupees 5 lakhs within
4 weeks.
within 4 weeks, and on such deposit, the respondents are at liberty to withdraw. Any conditions are there with regard to the amount?
Yes, my
The
lords.
petition number 1 being the wife is entitled so and so. Third respondent being insurance company is directed to deposit out of the compound. As per the order passed by the tribunal, as per the conditions laid down by the tribunal, the respondents are at liberty to withdraw the money.
11.
Yes, next.
Shankar DC.
Yes, all these matters, all the final hearing matters, from 14th, 2 matters a day.
11 and 12.
Yes.
There is enough solicitor.
This is
Settlement enough
ex parte
solicitor.
order, my lord. I have challenged.
I'm not hearing any final hearing
Yes.
matters.
Date.
Date, from 14th, every day 2 matters will be listed. 14, 15, 16, they'll give the dates.
11 and 12, 14.
12 also final hearing.
13
Yeah,
and
all the matters till the end.
13 and 14, 15. 16
Till
and
17, they'll give the dates from 14 through 2 matters a day.
17, any date, my lord, that is, we
17
consent
is
on
on
only.
18.
The last occasion, my lord, it was on the consent, my lord, we are ready to, my lord, argue the matter. It was posted.
That's what it will be given, date,
On the
immediate date
18th,
will be given.
Please,
Yes.
please.
Is any other matter? Where is that? Where is?
Put at end of the
Came
list.
notes.
Matter for
Serial number
settlement.
21
Yes.
came, both husband and wife.
Settlement.
Ask that lady to come.
Pass
What do you
over
say?
matters. Serial number
Pass over.
21,
Pass
pass
over.
over.
Yes. Lordship is ready now. The husband is ready, Lordship. Respondent is ready to take her.
Set up a separate home.
Yes, Lordship.
To set up a separate home. Or to take her.
Oh, take her, Lordship.
Not set up a separate home.
Not, he is not, only one house is there, Lordship.
Yes.
Your lordship, senior ಮಾತಾಡಿದೆ sir, ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಏನು.
Where is he?
Sir,
He should have come. I only asked
He's
him to come
appearing
up to
before
the
the-
next matter.
he is appearing before the court.
Come to the chamber. Once he is there, come to the chamber
Please, Lordship, please.
with the parties.
Please, Lordship.
Yes, signature. Where is that one? That matter also, if it comes when to
My
the
lord, serial number 10, I'll take notice, my lords, to respond number 6 and 7,
notice to respond.
please.
Notice to respond.
I'm appearing for
First,
1 to 5.
Aviator, my lords, is appearing for 1 to
1
5.
to 5.
I'll take notice to 6 and 7 only.
We'll say notice to, already council is appearing for respondents 1 to 5.
5.
Respondents 6
6 and 7, I'll take notice.
and 7 notice.
L sir may be called out.
Call for the TCR.
Please.
Done.
My lord, on submission. The compromise.
Is it come?
Opposite counsel
No,
is
no,
not here.
what you can do is once file has come.
File is
Yes.
2:30, my lord. Opposite
I'll
counsel.
take, parties are not there.
Parties, respondents are.
They come to the chamber at 2:30.
Much obliged.
This compromise matter, immediately the council comes in. Madam, dates for your report.
ಕೊಟ್ನಲ್ಲ serial number 11 and 12 14 7 13 and 14 15 7 15 and 16 17 7 ಅದು ಲಾಸ್ಟ್ ನಂಬರ್ 18 7
16 ಯಾಕೆ ಬಿಟ್ರಿ ಸಂಡೇ 16 ಯಾಕೆ
15 and 16 17 7 ಎರಡೆರಡು
16 ಯಾಕೆ ಬಿಟ್ರಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ
16 ಕೊಟ್ಟಿದ್ದೀನಪ್ಪ
ಅಲ್ಲಿ ಕೊಟ್ರಿ 15 ಆದ್ಮೇಲೆ 17 18 ಕೊಟ್ಟಿದ್ದೀರಾ
16 ವರ್ಕಿಂಗ್ ಡೇ ಅಲ್ಲ
ಹಾ
ಅದು 16 ಕೊಟ್ಬಿಡಿ
ಇದು 16 7 ಇದು ಲಾಸ್ಟ್ ಇದೆ 18 7
ಅದು ಅವ್ರು ಇದ್ದಲ್ಲ 18 7
ಅದು ನೋಟಿಸ್ ಅಂತ ಇದ್ರಲ್ಲಿ ಯಾವ್ದು ಮೇಡಮ್ ಅವ್ರು ಹೇಳಿದ್ದು ನೋಟಿಸ್
ಎನ್ ಕೆ ಪಾಟೀಲ್ ಅವನು ಇವರು ಅಶೋಕ್ ಎನ್ ಪಾಟೀಲ್ ಮಾಡ್ತಾರೆ
ಇದು
ಹಾ ಯಾವ್ದು ಇಲ್ಲ ಸರ್ ಅದು ಎರಡು ಮೇಡಮ್ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ 14 ಆನ್ವರ್ಡ್ಸ್ ಅಂತ ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ನಿಮ್ದು ಯಾವ್ದು ಅದೇ ಸರ್ ಹೇಳಿ ಯಾವ್ದು 13 ಯಾವ್ದು ಬೇಕು ನಿಮ್ಗೆ ಅಷ್ಟೆಲ್ಲ ಲಾಂಗ್ ಡೇಟ್ಸ್ ಮೇಡಮ್ ಹೇಳಿಲ್ಲ ಆಫ್ಟರ್ 14 to 2 in between 2 days ಡಿಫರೆನ್ಸ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಟ್ಲೀಸ್ಟ್ 21st ಅಂತ ಅದೊಂದು ಕೊಟ್ಬಿಡ ಸೇಲ್ ನಂಬರ್ 13
ಮೇಡಮ್ ಡಿಪಾಸಿಟ್ ಬಿಫೋರ್
ಅವರು ಡಿ ಎಸ್ ಹೊರಟೋದ್ರಾ ಫೈಲ್ ಕಳಿಸ್ಬಿಡ್ಬೇಕಂತ ಅವರು 6 ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6 ಅದು ಅಶೋಕ್ ಎನ್ ಪಾಟೀಲ್ ಫೈಲ್ ಸೀರಿಯಲ್ ನಂಬರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ 1 to 5 KVT ಇದ್ದಾರೆ 6 ಗೆ ನೋಟಿಸ್ಗೆ 6 and 7 ಸರ್ ನೋಟಿಸ್ ಟು 6 and 7 ಡೆಪಾಸಿಟ್ ಅದು ಏನು ಹೇಳೋದು ಗೊತ್ತಾಗಲಿಲ್ಲ
1 to 5 ಗೆ ಕೇವಟ್ರು ನೋಟಿಸ್ ಟು 6 and 7
ಇದು ಎರಡು ಅವರು ಅಡ್ವೊಕೇಟ್ ಬಂದ ತಕ್ಷಣ ಚೇಂಬರ್ಗೆ ಹೋಗ್ಬೇಕಂತಪ್ಪ ಅದು ಮ್ಯಾಟ್ರ್ ಅದೇ ಇದು ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್
ಫೈಲ್ ಎಲ್ಲ
ಪಾಸ್ ಓವರ್ ಅಷ್ಟೇ ಪಾಸ್ ಓವರ್ನು ಇನ್ ಚೇಂಬರ್
21 ಕೊಡಿ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಕೊಡಿ ಇದೆಲ್ಲ ಅವ್ರದಾ
ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್
21 ಕೊಡಿ
ಇದು ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್
ಇದು ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಶೀಟ್ ಕೊಡಿ ಅದು
ಆಯ್ತಾ
21 ಕೊಡಿ ಕರೆದ್ರು ಮೇಡಮ್ ನನ್ನ ಪೇರ್ಸ್
21
ನನ್ನ 22 7 ಎಲ್ಲಿ
ಅವ್ರೇನ್ ಫಾರ್ಮ್ಯಾಟ್ ಅವ್ರದ್ದೇನಿದೆ
ನೋಡ್ಕೊಳ್ಳಿ ಬರುತ್ತೆ ಸರ್
43 ನಾಟ್ 1 MF ಎಷ್ಟನೇ ಸೀರಿಯಲ್
ಆಗುತ್ತೆ
43
ಚೇಂಬರ್ ನಂಬರ್ ಏನೋ ಹೇಳ್ಬಿಡೋಣ
ಆ ಚೇಂಬರ್ ನಂಬರ್ ಗೊತ್ತಿಲ್ವಲ್ಲ ಈ 43 ನಾಟ್ 1 MF ಎಷ್ಟನೇ ಸೀರಿಯಲ್ ಇದೆ ಇದೆ ಅಶೋಕ್ ಎನ್ ಪಾಟೀಲ್ ಫೈಲ್
ಚೇಂಬರ್ ನಂಬರ್ ಏನಪ್ಪ
ಫೈಲ್ ಅಲ್ಲಿ ಇದೆಯಾ ನೋಡಿ ಒಂದು ಫೈಲ್
ಯಾರ ನಂಬರ್ ಗೊತ್ತಿದೆ ಆಸಿಫಾ ಮೇಡಮ್
ಹೋಗ್ತಾ ಇದ್ದೀನಿ
ಓಕೆ ಅಲ್ಲಿ ಹೋಗ್ತೀನಲ್ಲ ಈಗ
ಹೋಗ್ತಲ್ಲ ನಾವು ಹೇಳೋದಲ್ಲ ಡೇಟ್ಸ್ ಎಲ್ಲ
ಅಲ್ಲಿ ಹೋಗಿ ಹೇಳ್ತೀನಿ ಫೋನ್ ಮಾಡಿ ನಿಮಗೆ
ಸದಾ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಹೇಳು ಚೇಂಜಸ್ ಇದೆ ಇದು ನಮ್ ಚೇಂಬರ್ ಎರಡು ಫೈಲ್ ಕೊಟ್ಬಿಡು
ಚೇಂಬರ್ ನಂಬರ್ ಹೇಳಿ ಸರ್
ಮಳೆ ಬೇಕಾಯ್ತಾ
ಆಯ್ತು ಚೇಂಬರ್ ನಂಬರ್ ಹೇಳಿ
ನೋಡಿ ಹಿಂಗೆ ಪೇರೆಂಟ್ಸ್ ಕೊಡಿ ಆಫೀಸ್ ಹತ್ರ ಮಾತಾಡ್ತೀನಿ ಬೇರೆಯವ್ರು ಓದೋದನ್ನ ಮಾತ್ರ